So if you've decided to form a nonprofit organization, there are a few steps that you'll have to follow. The first step is you'll have to file articles of incorporation, right? So that's the first step in creating any new business entity. Here in the state of Ohio, those are filed with the Ohio Secretary of State, and that's generally going to be true in most states, although they might call their office something slightly different. For a nonprofit, there should certainly be articles of incorporation. Some states have allowed nonprofits to form as nonprofit LLCs, and while I won't get into all of the details today, just understand that that is an incredibly difficult option to follow if you end up filing for your tax exempt status with the IRS. So make your life simple, make sure you're filing articles of incorporation. Now, the articles of incorporation will typically ask for just some basic information: the corporation's name, where the principal office is located, the purpose of the organization, and the identity of the statutory agent. Now, clients tend to get very specific and flowery with their purpose language, and they'll often write themselves right out of the legal requirements for being recognized as a tax exempt organization. The IRS provides some suggested language that won't cause problems when you go to apply for your tax exempt status and they're actually reviewing your application. So their preferred language says, this corporation is organized exclusively for charitable, religious, educational, and scientific purposes, including for such purposes the making of distributions to organizations that qualify as exempt organizations under Section 501c3 of the Internal Revenue Code or the corresponding section of any future federal tax code. The purpose clause in your articles of incorporation really don't need to be any more complicated or more specific than that. And of course, if you're looking at a different type of 501c organization, then obviously you would need to make some adjustments there to the purpose clause. Now, the articles will also ask for a statutory agent in most states, and that's simply a person or business located in your state who is authorized to receive official notices. So whether that comes from the Secretary of State, another government agency, sometimes even the courts. Now, I cannot emphasize enough just how important it is to keep this information up to date with the Secretary of State. If an important notice is sent to your statutory agent, then the law generally assumes that the organization received that notice and was made aware of its contents. And I've seen clients lose important legal rights because a notice went to an old statutory agent address that was never updated with the Secretary of State. They didn't find out about it until after the deadline to respond to whatever the government notice was, and major problems resulted. So make sure that address is being kept up to date. Now, once that step is completed, your next step is to obtain a federal employer identification number, or what we commonly call a tax ID number. And that's what will allow the organization to open up a business bank account, of course, depending on your specific bank's requirements. The application can be completed online on the IRS website, and except in very rare situations, you will get the tax ID number immediately. Now, the IRS will also mail a confirmation letter, but that physical letter can take up to several weeks to arrive, although most people report getting it within the next few days. And while the IRS says that the confirmation letter is not necessary to open up a business bank account or to start using your tax ID number, these days most banks are requiring a little bit more, and they're often asking for an actual copy of the confirmation letter showing your tax ID number from the IRS. So make sure when that letter comes in the mail, you get it, you keep it, you make multiple copies, you save several copies in the cloud, you do whatever you have to do to make sure you don't lose that letter. That letter also is going to provide some really important information for your accountant. So if there are ever any questions about your tax status, particularly if your accountant is wondering how you might have answered some of the questions when you applied for that tax ID number, a lot of that information will be in the letter as well. Your next step, once we've gotten some of that preliminary paperwork out of the way, is to begin putting together the governing structure for the organization. And that involves drafting both bylaws and a conflict of interest policy. Now, the bylaws are going to dictate how important decisions get made within the nonprofit organization. So we frequently get information from both newer organizations, how do I put my bylaws together? Where can I find a template? As well as more established organizations. I'm not sure if we're following these bylaws. They were prepared a long time ago. How do we make updates? How do we fix them? We're not really sure what some of this old language is about. So, are bylaws really necessary? Is this legally required? And in Ohio, the nonprofit corporate law says that you have to have some sort of bylaws or code of regulations, and it uses those two words interchangeably. Under Ohio law, the incorporators, so that'd be the group of people or even the one person who established the nonprofit corporation by filing the articles with the Secretary of State, can adopt regulations or bylaws that govern the organization, how its affairs are conducted, how its property is managed, but nothing in the law requires an organization to do so. So if your organization does not adopt bylaws, then you're subject to the rules established in Ohio or whatever state you established your nonprofit organization in, and those default rules will govern the organization. Now, the problem is that typically you and your fellow board members are not intimately familiar with your state's code, and so just relying on default provisions in state law isn't really a good idea. Similarly, federal law does not require that you have specific provisions in your nonprofit bylaws, but you will find that you're asked about whether or not the organization has adopted bylaws when you go to apply for tax exempt status. So if you haven't, you're going to end up having to explain, well, how do we plan to govern the organization if we haven't put together bylaws? So it's usually easier to just go ahead and put the bylaws together. You'll also need to report significant changes to your bylaws when you file your annual 990 information return. So what should those bylaws include? There's a few things, We generally talk about what's the purpose of the nonprofit, right? And that should, of course, be consistent with what you put in the articles and any of the IRS filings that you have to make for the organization. Does the organization have members, right? And if so, what are the requirements for membership? Do they have to pay dues? Or are there a special category of non-voting members, right? So you start to get into those nitty-gritty details. How many people will serve on the board of directors? Here in Ohio, the minimum number of directors is generally 3. But the bylaws might also talk about what qualifications does a person need to have to serve as a director. Do they have to be an adult, or are you a youth-led organization? Are you looking for people with specific skill sets to fill specific roles? So the bylaws might address some of those concerns. How long can a person serve as a director? When a person is elected, how long will their term be? Will they have term limits? Are they only allowed to serve for so long before the organization wants to bring in new blood and fresh ideas? Or can they serve for as long as they wish to? The bylaws will often address how often board meetings will be held, right? So keep in mind that if your organization has members, then your bylaws should also address both membership meetings and meetings of the board of directors. But if you kept things simple, how often are the board of directors going to meet? All right, how will they get notified about an upcoming meeting? How many people have to attend the meeting to make up a quorum? And when you're addressing meetings, especially after the pandemic, don't forget to consider and specifically allow for meetings that are conducted over the telephone or over, other communications services or equipment like Zoom. And of course, your bylaw should also allow for written actions, right? So we can't get together, we can't wait until next month to make a decision. We need to make a decision this week. So we'll have a written action, right? We'll make a decision on paper instead of at a meeting. And typically all of the directors will sign off on that written action. Will the board have officers, right? Commonly we'll see a president, a vice president, a secretary, a treasurer, or something very similar to that. So what are those titles going to be? What qualifications do those people need to have? What duties and responsibilities do they have to the organization? How long will they serve in those roles? The bylaws will answer all of those questions. Does the board need to have any committees, right? And what authority will those committees have? Can the committees take action without board approval, or are they just making recommendations that are then taken back to the board of directors? Will the organization have any paid staff, right? And then who supervises those staff? Traditionally, it'll be the executive director, then supervises the rest of the staff. The board supervises the executive director, but of course, there's a lot of flexibility around exactly how that is structured. And while we generally prefer to cover most of your employment policies outside of the bylaws might often address, anti-nepotism language so that everyone's just not hiring, friends and family members to fill some of these important roles. What will be the organization's fiscal year, right? When and how will budgets be adopted? What financial information should be shared with the board members? Will any of the board members be compensated, which can be a very tricky area of law to deal with? Will the nonprofit organization indemnify its board members, its employees, or any other agents who might accidentally find themselves named in litigation related to the nonprofit? Will the organization carry directors and officers liability insurance to deal with some of that potential liability? And then, of course, unfortunately, people aren't always a good fit for their roles with a nonprofit. So, under what circumstances can a member, a director, or an officer be removed from that role? And what would that removal process look like? And then, of course, how can the bylaws or even the articles be amended or updated as the organization grows and develops and things change? So, a few best practices to keep in mind as you're putting together bylaws for your nonprofit, or you're looking at your bylaws and you're considering potential changes and updates. So, in drafting this document, you really want to strike a balance between being comprehensive while also maintaining some flexibility and not overly complicating matters. For example, if you have a relatively small nonprofit, it's in the early days, you probably don't need several committees and a complicated approval process for making decisions. But you might want to include language in the bylaws that allow the board to establish committees later on as the board sees fit and deems necessary. On the other hand, if you're a more established organization and you're going through the process of updating your bylaws, consider whether you've got some sections in there that have long been ignored, right? Committees that are no longer functioning, meeting dates that no longer work. You didn't have a provision authorizing all the Zoom meetings that we had to have over the pandemic, right? So you want to make sure that your bylaws are actually matching up with the way the organization is currently functioning. And of course, your bylaws should often address any governance issues that might arise without necessarily needing to be amended on a frequent basis. And so we'll often take a look at, should this really go in the bylaws, or does this need to be a separate policy document? Remember that the nonprofit bylaws are a legal document. So when internal disputes arise among the board or the members, or between the board and the executive directors, it's not unusual to see the bylaws suddenly become a weapon, especially if decisions haven't been made in the manner that's consistent with those bylaws. The directors have a duty to act in good faith and in the best interest of the organization. And it's really difficult to say you've met that standard if you haven't been acting in accordance with your own bylaws. And the directors can be held personally liable, including money damages, for actions that they take that deliberately injure the nonprofit organization or that recklessly disregard the best interests of the nonprofit organization. It's also important to remember that as your organization grows and matures, you want to make sure that you're keeping track of revisions, amendments, and updates to the bylaws. Particularly as nonprofit board members come and go over time, it's incredibly easy to lose track of, well, what version of the bylaws have been approved? What's the most recent version? What's the procedure for adopting amendments to the bylaws, right? Which one are we currently operating under? So make sure that you're keeping track of that. Now, in addition to the bylaws, your organization should go ahead and prepare a conflict of interest policy. The IRS will ask whether you have one when you apply for tax exempt status, so it's a lot easier to be able to check the box and say yes, rather than having to say no and explain how you plan to deal with conflicts of interest. Now, the conflict of interest policy addresses how the organization will deal with potential conflicts. So, for example, how will the organization deal with a board member that also wants to be paid for providing services to the nonprofit? How will the organization make sure that the board member is in fact the right service provider for the organization's needs, and that the board member is not being paid some exorbitant, above market rate for services just because they've got a position on the board? The other area where conflicts of interest are likely to arise is when you're setting up compensation for officers and directors, or even for the executive director. So the conflict of interest policy should prohibit anyone with a financial interest from voting on a compensation decision that they're going to benefit from. And again, particularly in newly formed nonprofits, there's often this mistaken belief that, well, if I'm the founder, I own the nonprofit. I can do whatever I want to do with the money that it raises, including setting my salary based on what my current standards of living are. And that is a huge no-no. The reality is that no one owns a nonprofit organization, and you would be jeopardizing your tax exempt status if you start setting or even voting on your own salary or compensation.